My name is Martin Fine. This presentation about managing the cost of disputes for small businesses has been prepared by myself and Alina Balistreri. We are with Conflict Resolution and Legal Services. What does hurting a steer named T-Bone have to do with managing the cost of small business disputes? There is the focused coordination and training of rider Cheryl and her horse and their mutual goal of hurting T-Bone. Yet, T-Bone can at any moment turn those intimidating horns on them. From my perspective, this is a snapshot of conflict management. To Cheryl, who is a small business owner of T2 Ranch, it is also about the bottom line. Can she keep T-Bone going in the direction she needs, and will T2 Ranch be able to make enough income after paying the mortgage, feed, and all the other overhead expenses? Conflict is a factor that needs to be included in calculating costs for a small business in order to maintain an accurate budget and assure a profit. Part of a good business plan is anticipating costs that may not be fully known but can be estimated. A good business plan integrates the information, analyzes the impacts, and considers strategies to minimize and manage these costs. A small business usually does not have the luxury of extra profits or income to put into a slush fund for rainy day legal expenses. Murphy's Law, which says that if something can go wrong, it will, is always a cloud over the small business budget. If you take into account conflict and the vacillation of human nature, asking how can a small business better manage the cost of disputes is simply good business practices. Many of these potential disputes for a small business involve legal issues, but business is also an important part of our financial security, life, and community. Thus, almost all business-related disputes also encompass a human and personal element involving relationships and friendships. For example, partnerships and many other business arrangements often involve issues of shared and joint responsibility and liability. Distribution of income and individual risks and benefits can also be areas of conflict. Issues of how best to manage and operate the business arise between owners, managers, and employees. As Adam Smith said, no complaint is more common than that of a scarcity of money. Whenever money, taxes, credit, and finance are involved, potential conflict is around the corner. When a business is engaged in a business transaction outside of the state, such as borrowing money, leasing equipment, establishing contracts, and selling goods, a state's version of the Uniform Commercial Code will apply. In California, this is referred to as the CCC, or California Commercial Code. This code is a comprehensive and complex regulation of these types of business dealings. Many people like the idea of getting involved in an established business through franchise agreements. Franchise agreements involve considerable planning and research. Areas of dispute often develop around the amount of control exerted by the franchisor, such as site location, design, restriction on goods and services, method of operation, and sales area. Intellectual property rights are a fertile area of dispute in this era of technology. Great ideas, logos, business names, and inventions need to be protected because someone will want to steal or copy it. The steps involved in filing for patents, trademarks, or copyrights help safeguard intellectual properties. Employees or vendors are sometimes required to sign non-disclosure agreements because they may at some time compete using your ideas, service area, and clients. Good management means that you, as a business owner, know the actual cost of conflict. If you have ever watched the show Restaurant Impossible, Chef Robert first looks at a failing restaurant's budget. Robert also spends considerable time with the staff and management addressing personal conflict in the business. Conflict is a matter of life and should also be considered within a budget for other types of businesses. While some conflict is productive for a business, conflict can also relate to loss of business and loss of income or profit. The first step is to identify the activities involved in unproductive conflict and attribute an estimated value. Depending upon the advice of your tax advisor, quantifying and documenting these costs may also be beneficial for tax deduction purposes. An example is legal and professional fees relating to a conflict, which may be deductible when the expense is an ordinary and necessary business expense and is reasonable in amount. Good business leaders are aware of basic conflict resolution principles. CRLS has a separate video on its website on this subject under the tab of Training Resources. This video explains the 4 cornerstones of conflict resolution. The first is to understand the nature of conflict and how conflict is typically resolved in our society. The second cornerstone we refer to as the conflict reactor, which looks at how our underlying interests affect a dispute. Number 3 is that conflict requires good communication. The fourth cornerstone underscores the importance of a clear and meaningful agreement in resolving conflict. A legal dispute involving attorneys in court is very expensive and may not be affordable for many small businesses. And yet, small businesses do not often utilize conflict resolution, which may be less costly. The data does not really tell us the details of what happens to a small business embroiled in conflict. Does the dispute not get resolved? Does the conflict linger? How much impact does a particular dispute have on the business's income? Small businesses may not have much experience or knowledge about conflict and the most effective means to resolve a dispute. One available option is small claims court. However, pursuing a small claims court action can also pose problems. A small claims court complaint is still a lawsuit involving the courts. Strong emotions can be triggered, which may make it more difficult to resolve a dispute in the long run. While small claims court saves money because attorneys are not involved, parties are also deprived of the knowledge and experience an attorney can provide. Many cases are usually scheduled for the same time and the calendar can be very crowded. Any one case is not allowed to take up a lot of time because the court has to get through its entire calendar. This is why it is so important to be well prepared so you can present your case quickly and efficiently. The judge may make a decision at your hearing or mail it to you later. If the judge needs to make additional inquiries or research a legal point, the judge may take the matter under submission. If this is the case, you will get the decision in the mail. It is not uncommon for the defendant to not appear or seek a continuance. A small claims court judgment may also be appealed, requiring a new hearing in Superior Court in which the parties can be represented by an attorney. A defendant that does not show up and receives a default judgment can still file a motion to vacate the default judgment. Winning in small claims court is only half the battle. The court will not collect the money for you, but the court will issue the orders and other documents you may need to collect your judgment from the debtor. Not all judgments are collectible because the debtor may not have any income or property of value. Many judgment debtors, the losing party, are unable to pay due to lack of assets. A great number of judgment creditors, the party who won the judgment, simply give up once collecting from an elusive judgment debtor becomes too time-consuming. However, perseverance in using a variety of tactics can increase a judgment creditor's chances of recovering the court-awarded debt. There are some initial steps you can take. Give the debtor an address where he or she can mail the money you are owed. You can offer to accept less than the whole judgment if the debtor pays right away. But if you agree to accept less than the whole judgment, you will give up your right to the rest of the money. If the debtor does not pay you by the date the court ordered, write him or her a letter, include a copy of the court order. Remind the debtor that he or she owes you the money and that you may have to follow more serious steps if he or she does not pay you voluntarily. Lastly, talk to a lawyer. If the debtor will not pay, it can be complicated, expensive, and take a lot of time to collect your money. A good plan can help avoid protracted and expensive disputes. The first step is education and training of yourself and others in your business. There are many free and affordable programs to help you. A good complaint and grievance process allows you to understand and address problems early. The longer a dispute is not dealt with, the greater chance it will mushroom into a costly problem. If litigation develops out of a dispute that could have been handled through a grievance procedure, it will be to your credit that there was an opportunity to resolve the dispute. However, if you do have a procedure, it is important to know and train those involved in the business, the process, and use it in good faith. Lastly, for problems that are more complex and difficult, the procedure can incorporate the step of independent conflict resolution or mediation. Small businesses need to think prevention because even one significant legal or customer dispute can damage the success and reputation of the business. Some of the best resources for small businesses are the organizations that assist them in being successful. Obtaining input and advice from others experienced in business may also be invaluable. It is helpful to have a continuum of conflict resolution options for different situations. Because of the difficulty of collecting a judgment, relying solely on small claims court may not be realistic. Taking control of your business plan will improve your chances of effectively managing complaints and disputes. Sometimes legal action cannot be avoided, but should be considered only as a last resort. A written guideline and procedure can be very helpful in avoiding costly disputes. If conflict resolution is needed, look to ways to minimize costs, such as group rates and discounts. Also discuss tax issues with your advisor before the dispute or during the early stages so you're prepared for the necessary documentation to maximize your deductible expenses. Thank you for your time. If you need any further information, please do not hesitate to contact us.